premise for your whole argument here seems to me to be faulty. So tell me
Actually,
why I'm wrong.
Your Honor, I would say that's not faulty. Well, you are a little faulty, rather, with all respect. I used to do a lot of trials.
I'm at risk of being faulty. Counsel agrees right there.
Yes, sir. Well, I've done a lot of trials, and frequently it's my experience the jury comes out and they say, Judge, we have a question.
This argument starts off with a simple claim that the jury may not have actually agreed on what happened, but almost immediately the court isn't buying it. And what follows is a back and forth where the justice keeps pressing one question: is this based on evidence or just speculation? And the deeper this goes, the harder it gets for the argument to hold up.
Some of us are thinking along these lines, and that's the way it appears to me in reading the record.
Well, I'm just reading what it says here. I'm just reading what I see in the record. And
yes,
again, I understand that there are people that will spot a flaw in what has been presented to them and say, why would you give us that? And then kind of come back and say, well, this jury's really smarter than these lawyers who gave us these instructions or who teed these instructions up for the judge.
Or they're saying, and what we believe is more likely, they're saying, Judge, we're not all in agreement. We are not unanimous. What we are asking the court to do is give us a little more guidance there.
How do we decide this issue in favor of your client based on anything other than speculation, though?
I would say it's not speculation, Your Honor. There's some further indications in the record that that he was not unanimous. The disagreement in the trial court concerned the effect of the jury's revelation that it did not unanimously find that he premeditated the killings. The record shows that only 5 minutes elapsed between the pause in the deliberations and the jury verdict. They were previously out for 2 hours. So it's unlikely on this record that the jury changed their minds in just 5 minutes, or that the verdict was based on a unanimous finding that premeditation was shown.
It still seems very speculative. We're kind of imagining what they were doing.
I don't think, well...
Can you direct us to a case where we've relied on time of deliberation as a factor in determining the validity of a jury's conclusion or a verdict?
I'm right offhand, no, Your Honor.
I don't think there is one.
I'm not aware of it.
I find it interesting that you call that part of the record. I suppose technically you're right, because the record will contain the time they left and the time they came back in. But I can't think of a case in any court where that has been a germane consideration along the lines you're proposing here.
Well,
I mean, it kind of follows that it's just as likely, if we were speculating, that Justice Kennedy's hypothetical was correct and that they were just kind of proposing something, and the minute the form was cleared, they had already agreed on everything, and so it only took 5 minutes to fill out the correct form. I mean, if we're going to speculate, you can kind of go both ways on that.
I don't know that it's speculation, because there are some other factors that were going on in this case with the jury and with the jury instructions that were going on that suggest that there was definitely a problem in the arguments as well with the state trying to direct the jurors to ignore a lot of things that were being said on behalf of the defendant or the appellant in this case. If you look, for example, at point number 5, where we're arguing the trial court erred in denying the defense request to amend the standard jury instructions to remove the reasonable qualifier from the definition of mitigating circumstances. In that instance, during the state attorney's closing, and this is part of that argument, you go to pages 3407 to 3409 of the record, The state's closing argues that if the jury finds any aggravator to be proven, it still has to be unanimous. And when you look at the mitigating circumstances, the argument continues, it can be anything. And then they're sort of poo-pooing the 45 mitigating circumstances that were submitted by the defendants, by the defense. And that goes into another issue with the instruction requiring, according to the state, that anything that reasonably indicates the death penalty is not appropriate could be considered as a mitigator. But then they're arguing about weighing that against the aggravation, the aggravators, that mitigating factor, which if it exists, does it reasonably indicate the death penalty is not appropriate. And suggesting that one aggravating, in the argument, that one aggravating factor can outweigh any mitigating factor shown by the defense. And that's where the federal constitutional law comes in. The argument by appellant is that the denial of a special jury instruction is reviewed for abuse of discretion. A special instruction must be supported by evidence. But we're asking arguing based on federal law that the standard jury instructions should remove the reasonable qualifier from the definition of mitigating circumstances. I'm sorry. I thought somebody was starting to say something. Florida's preliminary and final standard jury instructions for use in the penalty phase both include this reasonable or reasonably qualifier. But our argument is that should have no place in the jury room. It requires the court to address aggravating factors and mitigating circumstances that are reasonably established by the evidence. But the U.S. Supreme Court requires in capital cases that each juror must be allowed to consider all mitigating evidence. The state's argument then in closing really cuts against that. And it's our argument it should not. The cases, the chief cases in this area are, and I'm not sure of the pronunciation, but it looks like McCove versus North Carolina, which cites to Mills versus Maryland. The requested charge change to the standard instruction would have effectuated the defendant's right to be protected by federal and Florida due process clauses. That's one of the more important of the issues that we have in this case.
Even if we agree with you, though, don't we have to find that the court abused its discretion by adhering to the standard jury instruction?
Yes, Your Honor.
Okay.
That's argued also. In the facts of this particular case and how the trial progressed. The requested change to the standard instruction would have effectuated the defendant's right to be protected by the federal and Florida's due process clauses to have his jury correctly and intelligently instructed. The appellant has the right to heightened reliability in the capital process, in the proceedings, and the instruction that was requested would have effectuated his right.
I'm just struggling to understand how it's protecting somebody's right to essentially say you can have unreasonable mitigation. That seems to be what you're suggesting.
Your Honor, I don't think it's unreasonable mitigation.
Well, but you're quibbling with the word reasonable, right? Well, what's the opposite of reasonable? The opposite of reasonable, with which you quibble, is unreasonable.
Actually, There's no requirement. In fact, the federal case law is certainly.
So now we come to it. You can have unreasonable mitigation. This is about the wanted a constitutional right to have unreasonable mitigation.
I'm sorry, Your Honor, that's not what I meant. What we're saying is there's mitigation. It has a basis in fact. 45 mitigators with bases in fact were being argued against by the state as being things the jury should just disregard. And the jury should only go to it if it's reasonable. And then it goes on to argue that, the mitigating factors.
In this arena, isn't it the case that you've got two different things going on with suggested mitigation? You've got whether it is factually established, whether the underlying facts, in fact, obtained. But then you've got the question, even once you get over that hurdle, you've got the question of whether it is of a mitigating nature. And those are kind of two different things. The fact that somebody comes and says that this is mitigation doesn't mean it's mitigation.
This is one of those arguments where the outcome doesn't just depend on the law. It depends on whether the court believes the foundation of the argument in the first place. And in this case, that was clearly the battle. Let me know, what do you think? Was this just a real issue or speculation?